Good afternoon, everyone. I'm very happy to introduce this seminar, which is part of the Jean Monnet module Enacting European Values in Context. Our guest this afternoon is a great scholar in comparative constitutional law and comparative federalism, Professor Nicholas Aroney from the University of Queensland, Australia. Professor Aroney has been visiting several academic institutions in Italy in the last month. And now he has come to Pisa for the seminar. We are immensely grateful for this. I had the pleasure to be one of the editors of the Routledge Handbook of Subnational Constitutions and Constitutionalism with Professor Patricia Popelier and Professor Nicholas Aroney, who enriched this research work with its distinctive viewpoint. So that there was a continental viewpoint that was embodied by myself and Professor Popelier, and Professor Aroney's contribution was a great enrichment to our edited book. Today, Professor Aroney will give a presentation about constituent power in federal constitutions. Now I'm sharing the PowerPoint presentation and give him the floor. There will be some time for discussion, and please, thanks indeed for being here.
Well, thank you very much for such kind introduction and welcome. Dr. Delledonne, your hospitality has been wonderful, and we've enjoyed the city, but we've also enjoyed Italy. We've enjoyed Padua, Verona, Bolzano, Milan, and then we're going to go to Ravenna, and also Venice. So it's been a lovely trip, and enjoying it very much. And it's been very stimulating to talk about questions about multi-level or multi-jurisdictional government and federalism here in Italy with so many distinguished scholars who are very interested in these questions. So it's a real pleasure to share this with you. Today I'm going to talk about a research project that I'm working on with Professor Stephen Tierney at the University of Edinburgh. Some of you may know him, as well as Associate Professor George Duke, who's at Deakin University in Melbourne and works a lot in legal philosophy, political philosophy, and some in law as well. And our topic, as in fact my topic suggests from the screen, is about the question of the relationship between constituent power and federalism. And the project involves us approaching the question from both a theoretical point of view and an empirical and comparative point of view. And what we're going to try to do is to bring those two methodologies together in our project. So what I wanted to present to you today was some of our thoughts, or particularly my thoughts, about how the theoretical and the comparative empirical will fit together. Because I know that many of you will be aware that sometimes we work either at the theoretical end of the spectrum or at the comparative end of the spectrum. And we know the two have to work together somehow, but we do know that a lot of work is either in one domain or the other. We're going to try and work out how to bring them together. So that's essentially what I'm going to be discussing. In that sense, what I'm going to be talking about is about methodology, in a sense. But to get to that methodology, I'm going to try to explain the problem and the questions that we're trying to address, and then to explain how that methodology is going to be designed to try to address those problems. For that reason, because we are early in the project, I very much welcome your comments, your suggestions, and your criticisms about what I have to say. Because a major part of what I'm wanting to do is to receive feedback and critical perspectives from you so that we can refine our methodology and refine the way we're defining the research question. So now where's page down? There we go. So essentially the problem has to do with this. What is constituent power in the first place? Well, I'm sure many of you, probably all of you, are aware of the concept of constituent power, the idea that constituent power is the power to make a constitution. Have a distinction in constitutional theory that is often used. I mean, there are critics of this theory, but according to the theory, the constituent power is the power that makes the constitution, and the constitution contains, as it were, or establishes the constituted power. So we have that distinction. Now, there's a lot of theoretical discussion and debate around constituent power. The principal context in which that has happened has been in the context of the theory of the unitary state, a state where we conceive of one people, a singular people, and they somehow exercise constituent power to establish a constitution, and that constitution establishes a government that governs according to the constitution. And that could be more complex. We might have a separation of powers, we might have a legislature, an executive and a judiciary, but all of these are institutions of the one state. The roots of the theory of constituent power in French thinking and in some aspects of German thinking and Italian. Is there something I need to do here? Oh, that might be better. Okay. Reflects that unitary conception. Now, of course, federations and perhaps systems that we might call multi-level or multi-jurisdictional, regional, complicate this to the extent that they are dealing not with a singular people, a unitary one people, but a multiplicity of peoples, several states, in a sense. And I'm going to be exploring exactly what that might mean in a federal and regional context. But the initial point is, does the theory of constituent power explain, does it have the capacity to explain federations? Do federations fit within that framework? Does it need to be adjusted in order to fit that framework? Does federalism actually raise so many critical questions that one has to question the constituent power theory at all in the first place? So do you see how there's a sense in which, at least from my perspective, it's an open-ended set of questions around the relationship between classic formulations of the concept of constituent power on one hand and understandings of federal and regional and multi-jurisdictional systems on the other. And as I said, our methodology is around tackling this both from a theoretical and from a comparative empirical point of view. Oops. I did try those. Now I'm trying. There, that seems to have gone. So the question then is, when we think about it, is just to do with, at a methodological level, about how theory relates to empirical research. Because a lot of theory is deductive, that works from a principle, works out the implications and so forth, whereas empirical research tends to be bottom-up. It deals with empirical details, a multiplicity of facts, and tries to induce generalisations from it. So can the two methods be brought together to make them mutually illuminating? I think that this is one of the fundamental epistemological questions of all scientific and social scientific research, as well as I think we could say legal research, especially comparative legal research. It's easier, say, for a domestic lawyer to deal with, say, the legal system of a particular state, right? Because one has a concept of authority, sources of law, the laws that are made, the laws that are regulated. We have lots of disputes and questions around that, but it's a fairly straightforward and almost deductive sort of process. Whereas when one is doing comparative law, one is dealing with many countries, many systems, and one is comparing them. So one has a multiplicity of empirical factors and facts. And what's the point of comparative law is the big question in comparative law. What are we trying to do when we compare? What sort of generalisations are we trying to draw out of the multiplicity of detail? So that's the fundamental problem. And I could even put it in a different way. If we start this project with a definition of constituent power, we have to define it in a certain way that's adequate to the research question. And then what we ask is, well, how is constituent power manifested in federal systems. But then in having defined it in a certain way and asking how's it manifested, we may well determine the answers that we're going to get because of the definition of constituent power we use to do the investigation. Can the investigation itself generate a new conception of constituent power that is pluralised to the extent necessary, and there reconceive the whole concept? So, you know, the question is around circularity of reasoning, about what does it really mean to combine theory and practice, or theory and empirical research in that way. And so I want to dig a little deeper, because I think it's not just a question of working out how constituent power works with federalism, but constituent power as a theory has its own problems as well. So if we dig into even the disputes around the whole concept of constituent power itself, there's a lot of tensions. There are indeed radically different views about what we're talking about when we say constituent power in literature. So our project has to be aware of that dimension as well, and ask, does a comparative federalism sort of approach illuminate that some of those problems that are already there in the theory of constituent power, or not? So there's also that sort of issue. So what I'm suggesting is there's, in a sense, two sorts of problems we're dealing with. One is the general problems about constituent power theory in and of itself, without the complexity of adapting it to a federal system with many peoples as opposed to one people. But then we have the specific problem of how do you adapt it to a plural system. Now, I'm not going to go through the detail on this slide, but of course, when I say constituent power, most of you would say, oh yes, of course, if we walk down the street, we ask someone in the street, they would go, oh yes, Emmanuel Joseph Sayers, of course, you know, the origin of the concept of constituent power, and of course, Carl Schmitt, the German jurist as well. I only draw attention to them, though, not to try and work over what they said and the important differences between the way in which they perceive constituent power, but just to underscore that when you dig into what they said, they conceived the constituent power of the people or the nation as, again, unitary in nature, singular in nature. I'm definitely for CAS. I mean, he's writing in the context of the French Revolution. He's writing in the context of a situation where the concept of the French nation is a driving concept of the revolution. He's seeking to give effect to the authority and the power of the French nation, singular in nature. It did produce a French constitution through its many iterations, which has fairly persistently maintained its unitary character, even though it does engage in considerable administrative decentralisation. That's an issue. Carl Schmitt, interestingly, writing in Germany, as we know, famous federation, even, you know, now, but even before the Nazi regime, in terms of the Weimar Republic. So nonetheless, one finds in Schmitt a very interesting tension, and I'm not actually going to propose some interpretation or any deep understanding of him. I just noticed that there are some elements in his writings that are, again, emphasising this unitary conception of the constituent power, because it's sovereignty. It's the power to determine who's in and who's out. It's the power to determine what the nation is or what the people is. Even though, interestingly, in his book Constitutional Theory, he has a major section on the federal state and federalism, and in fact argues for quite an interesting conception of that, which some of you may know Professor Olivier Beau, right, who wrote a book on the theory of the federation, a French professor at the University of Paris, #2, and he uses quite a Schmittian sort of approach to characterising federalism. So I just make those comments, it's really parenthetical to the main point that I'm concerned about. Although it could turn out that we need to revisit writers like these and others to think through the consequences of our project. So what about constituent power itself? Now, what I want to say is to start to introduce the problems in the theory of constituent power itself is this problem of if constituent power is vested in the people, and it's the people that exercise the power to make a constitution, and that's the constituent power. The difficulty is that we don't know what the people is. We have even a distinction in philosophy between a mere multitude and a people or a nation. This idea of, well, how is it that they become a people in order to make the Constitution? And it's arguable that the very act of making the Constitution, it's the Constitution itself that defines the people. So is it some sort of magical thing that somehow the people emerge magically when the Constitution is made in their name when they didn't really exist beforehand to make it? Or do we have a more ethno-social cultural definition of the people that's not so political, and we root it in that sort of sense of national identity that might exist independent of politics? Look, I appreciate that in all of this, there's just so much controversy in behind how do we conceive of a people, how do you make a people? And even further beyond that, a lot of the debate around constituent power has to do with what does it mean for the people to act? Because, like, you know, they act in multitude. You know, how would the people out on the street act other than through some procedure, some institution, some form of representation that somehow enables them to speak, somehow enables them to act? But if that's the case, if there's a necessity for some sort of institution, procedure, or representation, or some combination of those, who makes that? And so there's a chicken and an egg problem, as we might say in English. There's also like lifting oneself up by the bootstraps sort of problem. How does it get started? How does it get started? So I think that creates a tension where some people theorise about constituent power as if it's always constrained within law and within procedures and institutions. And others who want to emphasise this concept that constituent power is always outside the law, beyond the law, over the law, greater than the law, can always step in and exercise that power to change the entire constitution. And so there's a tension in theories around how we understand constituent power in that respect. And others who look at these sorts of debates argue that these are interminable and unresolvable problems, and has led some scholars to reject the concept altogether, and to say that a constitution or a law derives its authority not from the power that made it in a more positivist, legal positivist sense, but from the inherent moral, political morality of what's being legislated, from the very justice of the law or the constitution that's adopted. So the further thing about constituent power, and these are all building blocks for thinking through to our project, so bear with me as I work my way through it. But conceptions of constituent power seem to have both a prospective and a retrospective significance, in the sense that how one conceives of the constituent power will determine the processes and institutions that create a constitution. So you see how there's this problem of circularity, because a few minutes ago I was talking in the other direction, wasn't I? But if we stop and go, well, if we think of the people in a certain sort of way, or we think of constituent power in a certain sort of way, it implies a constitution-making process that reflects that. So which comes first is another real puzzle, I think, embedded in the question. Further, it's arguable that given a certain procedure that is used to make a constitution, there's every reason to expect that that institutional procedure will shape the kind of constitution that emerges from the system, whether you call it path dependency, whether you call it theoretical and institutional consistency. So, for example, if we think of the people in a certain sort of way making the constitution, but we think the constitution needs to represent the people in its institutions, right? One is dealing with the same people, one's conceiving of them in the same structural way, you might expect a certain institutional similarity. If I can make it, I might come back to this later and give some illustrations of how I think that might work to spell it out. It can then shape how it's later, how the Constitution is later understood. So we can look at court decisions, and to an extent in the work that I did with Giacomo, we looked at this sort of question at a state and subnational level, but we looked at court decisions to some extent, and we were observing how is the subnational constitution conceived. And in another work I edited with John Kincaid on courts in federal systems, we also looked at the way courts interpret the federal system And we found that at critical junctures, it's not uncommon that the courts, when they're faced with the problem that the text of the Constitution doesn't resolve, and they have to think through what are the fundamentals of the Constitution, they will often then appeal to a certain conception of the constituent power to resolve the interpretive problem. And in the written paper that I'm working up here and another paper I've been writing lately, I'm trying to demonstrate that sort of a use. And then finally, it all has an influence on the amendment power. Because, of course, amending a constitution is like making a constitution. It's tantamount to exercising the constituent power. And in fact, there are some who would say it is a form of constituent power or it is constituent power, whereas it would be others who would say it's not, it's a type of constituted power, right? Because it's constituted by the Constitution. The Constitution determines an amending process. But it's a capacity to change the Constitution, which was the power that was exercised to make it in the first place. So you see the sort of issue in behind all of that. So what about the federal complications? And this is where we have to now start going to, I suppose, the other side of the coin. Ask ourselves, well, what do we mean by a federal system? What do we mean by a regional system? And look, there's a very well-developed distinction in federalism literature between federations that come about through aggregation and federations that come about through devolution. And the theory is that they have a significantly different constitutive logic. So federations that come about through aggregation occur where you have several independent states that agree to form a federation. And the federation comes into being, didn't exist beforehand, but is created by those states. The opposite theory, or actual institutional method, is one of devolution, where you have a single unitary state which for some reason decides to federalise or devolve or regionalise power by creating subnational units and giving them powers that are constitutional, which are not just subject to the power of the federal parliament or the federal government, but are actually constitutionally guaranteed. The end result is a system by aggregation and devolution could produce an outcome that looks pretty similar in practice, except that the origin is different and possibly the trajectory is different, at least at that level of analysis. Now, the interesting thing about this distinction between aggregation and devolution is that while there is reason to think it has explanatory power, there are difficulties with that distinction because it's very difficult to identify a pure case of aggregation and perhaps even a pure case of devolution. There's many systems, at least, which when you look at what happened, they look mixed. They involve certain elements that look aggregative and some elements that look devolutionary. Canada is sometimes offered an example of this because in Canada, even though we regard it as, one of the federations, we had those distinct colonies that did express through their political institutions a desire to federate. But the province of Canada, and this is before the federation, was one large province that consisted of what we now know as Ontario and Quebec. And part of the federating process was to split that province into two separate provinces, right? And that's the logic of devolution, of disaggregation, right? In the very act of federating, and then to federate those two together along with some of the other maritime provinces of Canada or colonies of Canada as well. So Canada, you saw both things happening at the same time. Now, I think we can say that, and I won't try and belabour examples, but even if you look at the Swiss system, which looks so aggregative, each canton seems to join on by agreement. But in 1848, when they modernised the Swiss constitution, it went to the cantons for approval, right? And actually, only a large majority of them agreed, and a minority disagreed, and were forced into being part of, as it were, the new federal system that was established because there'd been a brief civil war between, the majority cantons and this minority. So even a Swiss system can show sort of mixture, and it's a little messier than pure aggregation and maybe even pure devolution. Now, so what this underscores is another thing. Aggregation and devolution are sort of theoretical concepts, pure ideas, if you like, ideal types maybe. Reality seems to be a little more complex, but maybe the two concepts have some explanatory power. I do think they still have some explanatory power, but you've got to be careful with how you use them. The other interesting thing is that constitutions themselves sometimes use language which seeks to identify the nature of the constituent power, either expressly or implicitly. Sometimes they use the word sovereignty, which is arguably a stronger term, and they identify it as existing somewhere. So we can see a range of federal and federal-like constitutions and how they manage this. Some of them, in fact, quite a lot of the European ones, like the German one, seem to attribute sovereignty to the people, the German people as a whole, which is almost suggestive that the constitution derives its authority from the German people. But we can say that the German system is a lot less devolutionary and singular sort of people-oriented than that implies, because we know that there was historically the German Länder, and we know that the new German constitution did go to the legislatures of the Länder for approval before the basic law was adopted. And so Germany's a complex case. Even the United States of America, which famously says, "We the people of the United States," adopted language which is arguably ambiguous about this question, because it uses the word people in the singular, but states in the plural, and suggests that they are united. So what does that mean? The point is that federal constitutions can make a claim about where sovereignty lies or where the constituent power is located, acknowledging they're slightly different, they're different concepts. But what it actually says may not reflect the empirical reality. A political scientist or a historian might come along and say, look, actually what happened was this, and what the Constitution says might not be exactly what it says. But nonetheless, those who wrote it were in a position to determine what it said. So it is a reflection of a dominant view. The Swiss Constitution, it refers to both the people and the cantons in the plural. The Australian Constitution similarly seems to have this combination of people and many states, constituent states. So we have those sort of distinctions, and of course, many of you may be aware that the Constitution of Ethiopia is the most plural of all in its language, because it ascribes authority to, in the plural, the simple plural, peoples, nations and nationalities of Ethiopia. So it doesn't even claim to speak in the name of any singular people or nation at all. It's very explicit about the plurality embedded in the system. Now, when we come back to constituent power theory, it's interesting that those who started to think about constituent power and this question have started to acknowledge this problem. So Andrew Arato, whom you might know, wrote quite a lot of interesting and important work in the field of constituent power. And, you know, one of the things he draws attention to is that ambiguity in the US Constitution that I just mentioned. And he says that that's a fundamental ambiguity in that. Jürgen Habermas, you might know, reflecting on what's the constituent power behind the European Union, speaks of a pouvoir constituant mixed. So the idea of some sort of constituent power that's not just simply unitary, but reflects, say, the way in which the European Union is established on the peoples of Europe, and not just the singular people of Europe, and the complexity embedded in that. Stephen Tierney, my colleague working in this project, also discusses how this has worked in Scotland, for example. So another interesting and complicating thing about the theory of constituent power is, are we dealing with an act of will or a legitimating norm? Because the very word constituent power, the word power, in English at least, suggests that what you're talking about is power and will, not authority, justice and rightness. The term authority, and some scholars use the word constituent authority deliberately to sort of capture the sense that we're talking about an embedded concept as opposed to a will-based concept. But then here's the fundamental problem here, is that to the extent that it's about power and will, an exercise of power by the people, which we do see in, say, Carl Schmitt's theory of constituent power, right? Then how does it create a normativity? How is it that a sheer exercise of power produces a normatively binding constitution, right? But if it's merely normative, how is it related to the real politics of power? Constituent power, Martin Lachlan says, therefore, mediates between these two. It's actually the way in which we understand the relationship between sheer power and will and normativity on the other. He may be right, he may be wrong, but I draw attention to all of these questions because it helps to think through how we frame our research question, right? Because we have to think about these sorts of questions. So if it is about power, to the extent it's about power and will, we ask who exercises this power? How do they exercise it? That's on the fact side. But then we also ask, what are the norms that justify it, that give it authority, that give it the capacity, as it were, to authorise a constitution that we regard as morally binding? And what I like about Andrew Arado's work in his book is that he actually suggests that the concept of constituent power involves three difficult antinomies. One of them is the singular people versus the plural peoples. But I actually think his first two antinomies are also relevant to our project. The concept of the tension between an inchoate population or a mere multitude on one hand and an institutionalised set of procedures and government and representation through which a constitution is made. And also, secondly, that tension between, is constituent power exercised at a decisive moment as an act, or is it actually a process with many, many acts that all add up to the making of a constitution? Now, why I say this is that it seems to me that these three antinomies, and therefore these six sort of tension points, are actually helpful for us to think through what we're going to do with our project, because it seems to me to think through it that way will help us to frame the comparative dimensions of our investigation as well as the theoretical ones as well. And so we expect constituent power to be exercised through institutions and through procedures, and we expect that in a federal system, it somehow has to be adapted to a plurality of peoples as well as a singular people. And so the question is, who makes the decision, which institutions, which procedures, which people or peoples will do so? That's what the question becomes, particularly empirically. So this is why we need an empirical inquiry into the question. And so the procedure we're adopting is that we want to, on the basis of the current theory, develop some hypotheses that can be tested. Hypotheses that are based on the state of the literature, the state of the theory, but ones that we regard as things to be tested rather than, so that the empirical comparative study can sort of scrutinise those hypotheses and see whether they hold true or whether they need to be adjusted or abandoned altogether. However, to do that effectively, we now have to ask ourselves, how do we undertake that comparative empirical inquiry in a rigorous manner? So it depends on how you count them up. But there's anything between 25 and 35 federations in the world, maybe more, and there's many more. Yeah, like I think we could go to the room and some would say many more. It's a complex thing, isn't it, about how we define how many. All I want to say here is this: it's a small number, and sort of conceptually, if we had the resources, we could examine every single one of them to come to scrutinise what our research question in an empirical manner. But we don't have the resources to do that. And so we have to choose. So one of the real deep questions I'm wrestling with at the moment is, how do I choose my case studies? I've edited, I don't know how many books in this field. It might be 3 or 4, and I've done quite a few edited books. And I always edit a book and then look at it and I never feel satisfied. I shouldn't be downplaying the books, even the book that we did, but I always want to push the rigour further. And that's actually what I really appreciated about working with Giacomo as well as Patricia, was that there was something about, I think Patricia really did it, didn't she? She drives it in a certain methodological way to try and bring some rigour to the outcome, you know, and I found that really helpful, and I really appreciated working with the two of you around that. And in a sense, that's what I'm trying to do here in terms of case selection problem. So if I can only choose 9 countries for sheer logistical reasons, how do we choose which 9 countries? And that's one of the puzzles for me at the moment. Well, here's some hypotheses that is going to frame it, and then I'll talk about case selection, and then I'll finish and I'll some questions. I hope I'm not going too long. So it seems to me that here's some purely theoretical hypotheses that federal constitutions formed by aggregation will be based on a pluralised constituent power vested in the peoples, in the plural, of the original federating states. It's by definition what it is in a sense. Federal constitutions formed by devolution will be based on a singular or unitary constituent power vested in the people of the original federating state. That's maybe what you might expect. And of course, both systems are then moving towards pluralism or singularity from that starting point. So that's what we might expect. We might further hypothesise, and this is building on what I said earlier, that federal constitutions formed by particular decision-making processes will tend to reproduce those processes in the design of their representative institutions and amendment procedures. Now, this is actually something that I argued in one of my books in 2009 and an article I published in the American Journal of Comparative Law in 2006. So this has been on my mind for a long time. And I thought that I had demonstrated that proposition by looking at Australia, Canada, the US and Switzerland, and thought that I could show that if you looked at the way the Constitution was made, you saw this systemic effect on its representative institutions and its amending clauses. So that each federal system had its own unique federating logic built into that, the way constituent power was structured. Because each of those 4 have a different structuring. They're all 4 are similar because they're somewhat aggregative, right? But they still have their differences, and I thought we could demonstrate that. And I said at the end of that article, I think this is shown, but the question is, can you show it with more countries? So the hypothesis here is, as a generalisation, that holds true for other systems as well, but we're going to test that proposition. And the question is, to what extent will it be held strong or true or not? I think the 4th and the 5th hypotheses are really building on something I just mentioned a moment ago. When you have an aggregative system, you're moving from a plurality of states to unity because you're creating one federation. But the very point of a federation is you still preserve the original separate powers and identities of the federating parties. Whereas if you have a devolutionary system, you're moving from one to many, but while retaining the one. So that's just a pretty straightforward observation about the internal logic of the ideal type of aggregation and devolution. Here's another thought, though, that I think is really important to notice. And I don't know that it's always noticed as much as it should be. And that is that the purest concept of aggregation is premised on the sovereign equality of the constituent states. And this is where I think that an international system reflects this in the most pure way. If we think of the fundamentals of international law, the most fundamental principle of modern conceptions of international law is that all of the states are equal in their sovereignty and sovereign equals. So if that's the premise of a strong aggregative system, it will be formed based on that premise. And so that sort of logic will drive the equality and sovereignty of the constituent states. And I think you see that strongly in Australia and the United States, and Switzerland, where the concept of Switzerland's a slightly unusual case with the half cantons, right? That's the point here about, you know, the complexity of it. But because of Australia and the United States, where they both were sovereign equals, they persist as sovereign equals through the system. Whereas in Canada, they were not sovereign equals, and nor are they under the system. In Germany, they were not equals, and nor are they under the system, in the sense that in the representation in the upper house, right? The lander are not equally represented, but more roughly in proportion to population, whereas in Australia and the United States, equally. So this is another sort of reflection of a hypothesis that one might expect with aggregative systems, as between equality and inequality in the system. And I've worked on a paper with one of my students looking at representation in federal systems, where we try to map out the variations in representative structures and match them to the processes by which they were made in the first place, and draw that distinction between equality and inequality as being a fundamental line of distinction. So let me now turn to case selection and I'll finish. So how are we going to select our cases? Well, I think many of you will know of Rand Herschel's book on comparative constitutional law, and one of the chapters, as well as an article, is I think some very good work on principles of case selection. So if I use that as a starting point, I identify from him, and he's borrowing from John Stuart Mill and I'm borrowing from both of them, is the concept that, well, we can have a similar cases method or a different cases method. These methods are designed to try and overcome the limitations of social science research, where we can't construct experiments and we have a limited number of cases. So how do we draw generalisations empirically from a small number of cases and not being able to conduct a controlled experiment? Well, these methods are methods to try and do the best you can to try to reduce the margin of error. And so most similar cases methods is this, that you try to compare cases, countries, federal systems that are the most similar, but are different in one question, one variation or variable of interest. And that is a way of trying to identify the significance of that one variable. And you might draw some conclusions about its significance, even some causal inferences possibly. The reverse, most different cases, is you pick cases that are radically different but have one variable in common, and that too is a way of trying to identify the significance of that one common element. The most difficult case and the most favourable case methods are a little bit different. They are about this, that if you have a hypothesis, this is how I understand it. If you have a hypothesis and you want to test it, well, the best country to test it against is the one that's the most difficult. Because if you can still establish, if the hypothesis is confirmed with the hardest case, for whatever reason you might think that it's less likely to confirm the hypothesis, then you've got strong reason for thinking the hypothesis might be confirmed in easier cases. And a most favourable case method sort of does the opposite, tests the significance of the variable by seeking to determine whether the causal or explanatory relationship exists in the most innocent or easy cases. Prototypical cases are cases that have within themselves as many or the most possible variables and conditions, or are the most representative amongst the many. Whether that's a helpful sort of method, it's something worth bearing in mind. Outlier cases are cases that are just outside the theory, that just you can't explain very well. Examining them could press your theory, could help you to develop new theory. So they're in the background. They're sort of like methods that I have in mind when we come to this. I expect that most similar in different cases is the most obvious choice combination, because you can combine your methods as well and try and get the merits of both in your empirical examination of these things. Now, then the next question is, well, if we're going to look for similar cases in different cases, what makes cases relevantly similar or different? So, given our hypotheses about aggregation, obviously what we want is a sample of cases where we have aggregative systems and devolutionary systems, so that we're creating similar cases through that and also different cases through that in that way. Because aggregation and devolution are obviously things that one would expect to have significance. Still creates that chicken and an egg problem, remember, because why do I say a system is aggregated? Because I've looked at how it was made. But then we analyse how it was made to see if it really is aggregated. We sort of go around in the circle. So there's a question there about methodologically, we've got to do the best we can based on the existing knowledge about conceptions of whether something is aggregated or devolutionary.
Another complicating factor is endogenous versus exogenous effects or factors, because most federal theory treats the system endogenously. Like it's either an aggregative system because these states agreed, or it's a devolutionary system because this one state decided, right? But we know that the reality of what happens is that there are third parties, other nations, other empires, other systems that influence. So, you know, Canada and Australia were formed within the British Empire under the authority of the British Parliament, right? What's the significance of that? The German and Austrian systems were formed after the Second World War under the control of the Allied forces, which expected them to do X, Y, and Z. And then, you know, the examples can be multiplied in terms of many of the more recent systems, federal-like systems, Bosnia and Herzegovina, or Nepal, or Iraq, all of these. There's a lot of external influence. So one has to also think, well, what is the significance of that, the concept of constituent power? I think that's another significant variable. And then the third type of variable, I think, has to do with what we would call diversity. What we would call cultural, linguistic, ethnic diversity, and maybe the question of national identity or multiple national identities. Because there's reason to think that if you're dealing with a, let's just say, I'll call it a country for want of a better word, which is very homogenous, the same race, the same ethnicity, the same language, the same religion, right, same culture, you would expect it to be more unitary in its outlook. There's reason to expect that. Versus a country that's highly fractionalised in the sense of many ethnicities, many languages, many religions, right? You would expect different national identities. What do you expect of that? And this is building a little bit on the, you know, some of the hypotheses that we developed in our book. We use these two sorts of ways of thinking about it to test it, and it seemed to me that it's very relevant to do that. I do mention at the bottom there some other distinctions between legal systems and continents and regions. You can see that I've said that. It sort of makes sense that we want to know what common law and civil law systems are going to look like. We probably want to have a sense of continental variety as well. We can go into all of that. But what I want to finish with is this question about homogeneity, heterogeneity, fractionalism and polarisation. And I'll finish. That's just a very quick point that I made a moment ago on that slide about exogenous, aggregative and devolutionary. What I want to suggest is that it's not just a matter of asking, is something aggregative or devolutionary? It's also a matter of asking how much is it, as it were, endogenous or exogenous? Because a system, and it seems to me that we can see, how do I put this? The Australian system, probably because I know it's, I think it's a classic example of this, that it's highly exogenous to the extent that the British Parliament enacted the federal constitution, right? But the political reality was it was highly aggregative because the actual political representatives and peoples, always in the plural, of the colonies went about deciding to federate and drafted the federation, the federal constitution, right? So our system sort of sits somewhere along that spectrum, actually along, you know, this line going along that way. Do you see the point? It's a way of just conceptualising the area. But let me now turn to, finally, questions of fractionalisation. And this is a map based on the data from an article by Theodon. A lot of social scientists who are interested in the relationship between homogeneity and heterogeneity in cultures, things like economic development or conflict, right? And I'm not interested in the economic and the, well, I am, we all care about those things, but I'm interested in their data on fractionalisation. Somebody put together this map. I don't know how accurate it is, but it's based on Theodon's data, and the blue countries are the ones that are not very fractionalised, and the darker red countries are highly fractionalised. What does fractionalisation mean? It's the opposite of homogeneity, in the sense that homogeneity, as I said, is many religions, languages, cultures, ethnicities, national identities, etc. Right? Whereas fractionalisation is many of them. So homogeneity or heterogeneity in that sense. So that Australia is quite a homogenous country on these measures. English is the most common language, most are Anglo-Saxon, most are Christian Protestant, oh no, it's actually Christian Catholic, but Christian. So you see there's sort of like there's this strong homogeny. People, you can see Germany there, it's pretty dark blue because it's seen as fairly homogenous as well in this calculation. But you can see that Belgium see how it's pretty orange there because we know that it's quite diverse. I'll come back to the Belgian case in a minute because I think that's not the only way of thinking about this issue. But you see India, you know, I'm picking out the federations here, see how dark it is. It's red. Canada is also orange, whereas America is light blue. You can understand how this is giving reflection to probably what your anticipations are roughly. Right? Now, that's helpful. But what I want to suggest is not the only issue because in this literature, there's also a category known as polarisation, which is not the same as fractionalisation. So fractionalisation is, imagine, many ethnicities. Polarisation is when there are two big ethnicities. So the most polarised situation is 51% and 49% of the population being of the two ethnicities, right? That's maximal polarisation. Reduced polarisation and more heterogeneity or fractionalisation is, you know, many of the hundreds of these little groups. Homogeneity is just one. What that produces actually is a diagram that has this shape, where the countries of the world are mapped in this sort of a way. So in the bottom for you, left-hand corner, right, are countries that are highly homogeneous. Yeah, this is a tracking of them. As they get to the point, they become highly polarised and there's only two large ethnic groups at loggerheads. And then going in the other direction up the top is fractionalisation, and they're the most fractionalised countries. And I've highlighted in blue the countries that are federal. And do you see how, if you can read it, everyone expect, where would Bill expect Belgium to be? As you'd expect, it's here, right? Highly polarised because you've got two large groups, similarly large, addressing each other. Whereas down here, this is Austria, right? Much relatively more homogeneous. Of course, it's always a matter of degree, right? And then if you work our way up here, there's India, highly, quite fractionalised. You know, what's interesting is that most federations sitting in this more moderate area here, you know, there's Canada, right? So it's on this data, and this is hard social science data, it's seen as less polarised in Belgium. Maybe that's right when we think about it, because while Quebec's a major factor, the English-speaking population is much larger than the French, right? Whereas in Belgium, the two groups are more equally matched. And that's a difference. It seems to me that this is another measure that's really important for my research project. If I want to get a selection, a representative sample, I need to think about it this way. And here's my final diagram, which lays out a selection of federal countries, quite a lot of them. And it's two indices, one of ethnic fractionalisation and one of ethnic polarisation, the same two measures. And if you look, it's pretty interesting to do this. This column here, this is the most fractionalised country. The most unfractionalised or homogenous. It's Italy and Austria. Did you like that? Right? It might be what you'd expect. I mean, this is the hard social science data. This column here is polarisation. Belgium is the most polarised. Italy is the least polarised again. Now, what I highlight there is that gives us a sense of, well, if we're going to have a representative sample, we want countries across these two spectrums. These two columns are just the same data. It's the same data. But what I'm trying to show is that when you rank them in terms of polarisation, this is what they look like in their fractionalisation, and vice versa, which shows there's not a close correlation between the two. Although, interestingly, Italy and Austria are the same. So I put into bold the cases that struck me as interesting. And the two interesting ones are Italy and Austria because they actually do correlate both, right? But that makes sense in a sense, right? That you'd expect like if you're very homogenous, you're not polarised and you're not fractionalised, right? So it sort of makes sense that they're going to, you know, whereas you don't see the same polarisation. correlation between Belgium. See how Belgium here is super strong in polarisation, but moderate in fractionalisation. And Canada here is sort of moderate, but I suppose it's the difference in colour that's really quite noticeable. And of course, India and Kenya are interesting cases too, to see the contrast between fractionalisation in those countries, but the relatively low polarisation. Now, data like this is only as good as the social science behind it. I'm not about to try and reproduce the social science because it's not my thing. But my plan is to take the best social science work that I can find and work through my case selection using this sort of principle. So that's where I want to finish. I hope I didn't go too long. I probably didn't I? Because I really want to hear from you to say, what are the holes in what I've just said? Say nice things to me, but I'm actually interested in, things that you think are problems or improvements. Thank you for your attention.
Thanks indeed.